Okay, we're going to repeat these at the end. I think it's very important. All right, so let's go to Mr. Beckles. We're on a road tonight. Again, we're running a little late, but everything will be covered. So,
Okay.
good
Good
night,
evening.
sir.
Yeah, good
Yeah,
night.
good evening. How are you?
I'm doing well. What about
Well,
you?
it's great, great. It's a pleasure to have you back on the program tonight. And you are talking about beneficiaries, the rights of beneficiaries.
Yes, indeed.
Go right ahead.
Right. Yeah. So, yeah, the rights of beneficiaries. This issue comes up a lot in practice in estate planning. Beneficiaries are always trying to find out information on estates, find out information on whether or not the will has been probated, whether or not it is time for the asset to be distributed to them. And you find that beneficiaries end up being, I would say, ignored. They're either ignored or they hear the words, I can't share that information with you. So that is why it is very important that the beneficiaries are aware of their rights as it relates to estate law. I want to start with the will.
Okay, seems stuck again. I think it will be good. Continue. Just we know what happened. Continue.
Right. Yeah, no problem. I'm going to start with the will, the rights of beneficiaries under a last will and testament. So we know that the will, there's an executor. Now, there's nothing that I am aware of in the law of Barbados that gives beneficiaries the right to be notified when there's a will. There's nothing in law that I'm aware of that gives beneficiaries the right to be notified of what is contained in the will before the will is probated.
Mm.
Nothing in law that I'm aware of. However, we find, and persons are aware of, we watch movies, we watch TV shows, where persons, where the attorney sits down with the beneficiaries and they read the will. So you call that experience the reading of the will. Everyone who has an interest in the estate comes into the attorney's office and they sit down while the attorney reads the will. It is not a practice that you see a lot, or we have seen a lot in Barbados, but it is happening. You are finding that more and more attorneys are using the opportunity to call in all the family members, call in all the beneficiaries, and have that event called the reading of the will. And I believe that is, I believe it is best practice
Mm.
because the beneficiaries, the testator or the testatrix, the male or the female who would have written their will, they want the assets to go to the beneficiaries. And I strongly believe that as long as the testator or testatrix passes and the executor has been named, even though the grant of probate has not been granted as yet, even though the will has not been probated, I still believe it is best practice to at least notify the beneficiaries. Let them know what is happening. Because you may find situations where the executor, when probate has been granted, the executor now has to sell the assets, the same assets that the testator or testatrix wanted to give to the beneficiaries. The executor now has to sell the assets to either pay debts or even give
Oh,
monetary gifts. Yes, yeah. Yeah, so the executor, and this is a very important point, all debts have to be paid first. All debts
uh-huh.
accruing to the deceased before they passed have to be paid. In fact, all debts to the estate have to be paid first before even any distribution is made. So that is why I say it is important that the beneficiaries understand the entire process. And what will happen is that the executor will go to the attorney
Mm-hmm.
and retains the attorney to probate the will. Now we know that there is attorney-client privilege. So that is where you will find the beneficiary is now trying to contact the attorney. They may not
Yeah.
get hold of the executor. They're trying to contact the attorney, and the attorney says, well, I can't share that information with you. It is not that the attorney necessarily doesn't want you to know anything about the estate, but the attorney is limited to sharing information. The attorney can only share information with the executor or to anyone the executor instructs him or her to give that information to. That is why it is important that the attorney advises the executor that you should be transparent. You're representing the estate, and the estate has beneficiaries. It means the executor really is supposed to be acting for the benefit of the beneficiaries named in the will. So it's up now to the attorney to let the executor know, okay, I know that you're named as executor. I know that the testator or testatrix gave you this power. They gave you the authority, but you're really supposed to exercise this authority, not for your own benefit, but for the benefit of those persons whose names are contained in the will. And that is important because the executor should be instructing the attorney to be as transparent as possible with the beneficiaries. So even though there's not necessarily a right in law for the beneficiaries to have any information before the will is probated, you still need to be transparent, because in the event that that asset has to be sold, now the beneficiary is caught off guard, and the beneficiary is now trying to understand, why can I not have the benefit of this asset? You're telling me that you went and sell the property. Why? Now the executor has to explain the situation from the beginning, when he could have done that. He could have done that at the first opportunity and let the beneficiaries know, well, based on the accounts, based on the amount of money that I'm seeing here in this estate, it seems that one of these assets have to be sold to be able to pay.
So can I ask a question? Who makes a decision on which asset to be sold in order to pay the debt? How do you make that decision?
Right. So the executor is the person with the authority to make that decision. And the executor can make that decision, well, can only make that decision after the will is probated. Now, prior to the probate of the will, the executor will speak to his attorney, his or her attorney, and the attorney may advise him and him or her and say, well, but we have two assets. One is valued at 50,000. We have a plot of land valued at 50,000, and we have a house and land valued at 100,000. Let's say the debt is in the region of 75,000. The attorney will advise the executor, well, it is best to sell the property with the greater value to be able to pay the debts, and you will still have maybe at least $25,000 left back that can be distributed to the beneficiaries. So it all comes down to what is best in these circumstances. That decision is based on what is best for all the beneficiaries and best for the estate. And that really is how the decisions are made. But the power to make that decision is in the hands of the executor.
Wow.
The named executor. Right? So transparency is extremely important. Not only transparency, when the will is probated, the executor is also accountable for his or her actions. The executor is accountable to the beneficiaries. So this is where we come into full circle, into the rights of the beneficiaries. So the beneficiaries have the right to make the executor account for what they have done with the estate since they were granted probate, since probate was granted. Since they were issued with the letters what we call letters testamentary, what have you done with the estate? Have you started the process of transferring the property from the estate to the beneficiaries? The beneficiaries have the right to know. They have a right to call the executor into account. Right. I know some questions are coming as I continue.
Yes.
Right. What if someone while pursuing a will goes into stage dementia? And I believe you're talking about the executor. If the executor basically becomes mentally incapacitated, then the process has to stop. As long as it has been medically confirmed that the executor no longer has the mental capacity to sign legal documents to continue the process, then you will have to stop the probate process. If there is more than one executor, then the other executor can, they will have to recommence the process, because you can't continue what someone else has started. The new executor or the other executor will have to start the process over again to completion. If there is no executor, then this is where the rights of the beneficiaries also come into play. Because if there is no executor, if there is an executor who lacks the mental capacity, a beneficiary now is able to make an application to the court for letters of administration with the will attached. So the court is still going to the registry, probate registry is still going to approve the will, but this is not just the usual application where you're asking the probate registry to probate the will. This is going to be an administration application, because someone other than the executor is making the application. So if there's no executor to be found at all, the beneficiary can now apply, the beneficiaries of the will can apply for letters of administration. Right. Quickly, what happens if the attorney that has knowledge of the will is deceased? This is where I would say proper planning comes into play. It is best practice after an attorney drafts a will and the will is signed, fully executed, that the attorney takes the will into the registry of the Supreme Court and lodge the will, lodge the original will at the registry of the Supreme Court. And when that will is lodged, then you're going to get a receipt. And that receipt should be shared with the testator, testatrix, or even shared with the executor, whoever is named as the executor of the will, so that there's more than one individual that knows where the will
Yes.
Right. There's more than one individual should know where the will is, where that original will is lodged. Now, there are some attorneys who may keep the original will at their office. And there may be attorneys that have the wherewithal, they may have the necessary security, the necessary vault, fireproof safe to be able to keep the will. But I do not prefer that practice. I prefer that as long as you draft the will, as long as the will is executed, take that original will and lodge it at the Supreme Court registry, so everyone knows where it is. And it takes the responsibility of trying to locate the original will out of the attorney's hands, because it is now safe. It is now kept safe at the registry of the Supreme Court.
Yes.
Right. We have a question: if the debt is less than the value of the property, right, could the beneficiaries be given the option to inject funds to pay off the debts rather than selling the property? Yes, that is possible.
Okay.
Remember, everything is supposed to be done for the benefit of the beneficiaries. Right. I'm back now.
Yes, you are. You're back.
Right. Yes. So the beneficiaries, everything is supposed to be done for the benefit of the beneficiaries. So the beneficiaries can come together, speak to the executor along with the attorney, and let them know what they want to do. So if the beneficiaries are willing to use their own funds to save the asset, to save the physical asset, I see nothing in law preventing that from occurring, as long as the beneficiaries who are entitled to that specific asset are making the decision. And the executor really should listen. The executor should not go off on their own and do as they please. They should at least listen to what the beneficiaries have to say.
Yes. Yes.
And if it is that what the beneficiaries are proposing may not necessarily work out for the best or for the better, that is a decision-making process. At least the executor can say, I listen to what the beneficiaries have to say. But the executor is not supposed to ignore the beneficiaries or ignore the wishes and desires of the beneficiaries. Right? What happens if a person expects to be a beneficiary because of relationship with the testator finds himself out of the will? Right. And a person, yes, can have that, they may have that expectation. They may believe that because of their close relationship to the testator, more than likely the testator is going to put them in their will. And sometimes they find out that that was not the case. And there are persons who decide that they're going to challenge the will or contest the will in a court of law. And persons are entitled to contest wills, but you can only contest a will on specific grounds. You can only contest a will on the ground that the testator or testatrix lacked mental capacity, or what we call testamentary capacity. They did not have the mental capacity to make a will, to make decisions concerning their assets. Or you can also contest the will on the fact that the testator, even though they had the mental capacity, they did not approve the contents of the will. So let's say that a testator gives instructions to their attorney, but for some reason something happened, and the instructions that were given are not a true reflection of what is, or the will is not a true reflection of the instructions that were given by the testator. And somehow there is someone who knew the real instructions of the testator, and they recognize that the will is slightly different than what they believe the testator wanted. Then they can challenge or contest the will on that fact, that the will does not contain a true reflection of what the testator wanted, that the testator did not approve or had no knowledge of the content of the will. And if he or she did, they would never have allowed that will to go through. And you can also contest the will on the fact that the testator or testatrix was unduly influenced to draft, not just draft the will, but to sign the will, unduly influenced to give the asset to someone that they really never intended to give the asset to. Right? So I hope that answers the question. Right? Should the owner of a will check to see if their will has been lodged? Yes. The owner of a will, so they go to the attorney drafts the will. The attorney makes sure that the will is signed by the testator or testatrix in the presence of two witnesses. And as I said, once the original will is lodged, you should get a receipt. And the owner should go back to the attorney and ask for that receipt. And that receipt is proof that the original will was lodged. So I will always strongly advise persons who have made their will, they have spoken to an attorney and they know that the will has been signed and witnessed, make sure that they obtain the receipt that is proof that the will was lodged. If there is no proof that the will was lodged, then sometimes it makes it more difficult even to locate the will if something unfortunate occurs. So as we continue concerning the rights of the beneficiaries, as I was speaking about the accountability of the executor, the beneficiaries can call the executor to account. And the beneficiaries can ask the executor to provide a financial accounting of their actions concerning the estate, a financial accounting. And that is if you have complex estates, you have a estate with funds in the bank, the executor has to show what he or she have done with the assets since they received the grant of probate. Now, the executor is account. Yes, the executor has to account, but really and truly, if there is a physical asset, the executor's responsibility, main responsibility, is to distribute the asset to the beneficiaries named in the will. So as soon as the executor obtains the grant of probate and make sure that all of the debts are cleared, make sure that there is no outstanding liabilities to the estate, the executor next move should be distributing, transferring the property from the estate to the named beneficiaries. That is one of the main responsibilities of the executor, giving the assets to the beneficiaries who are entitled to those assets. This is where the executor, I'm seeing another question, is a family member and drags on the process for a long period of time. Is there a reasonable time the court will allow for the executor to complete? No. The law states that the executor or administrator is supposed to file an account within 12 months, within a year's time. Within a year's time, the law allows for distribution. All the issues surrounding the estate and distribution of the estate to at least be settled within a year's time. So that is why the law states, or the law requires the executor or the administrator to file an account at the probate registry within a year's time of receiving the grant. But we know that there's some estates that are still outstanding for 2 years, 3 years, 4 years, 5 years. Well, it can go on and on, Marcia. There are estates that have been outstanding, still have not been settled for more than 20 years. And this is the unfortunate thing. This is the unfortunate thing that we find. I find it in Barbados, maybe also in the Caribbean space. And this comes down now to when you are choosing your executor, because there are persons who are drafting their will and they may choose their friend as the executor. And it's all well and good to choose your friend. But when you are no longer in this world, your friend continues their life. They have their own family. They have their own business to attend to. And if your friend is not named in the will, your friend is not motivated. Your friend is not motivated to settle your estate. So that is why I always advise individuals, at least name your beneficiary as your executor. It is possible, it is legally allowed to name a beneficiary as your executor, because you know for sure that the beneficiary will want the asset. They will want to receive the full benefit of what has been given to them. So they will make sure that the will is probated. But if you give executorship to someone who has no connection whatsoever to the estate, it is highly likely that you're going to find that estate is going to take us extremely long time to be settled. And it takes an extremely long time to be settled because sometimes the executor themselves don't even want to pay money. They don't even want to retain an attorney. They don't want to use their own money to retain an attorney to start the process, the probate process.
Because they're not. I mean, this is so interesting. Maybe I need to go and do some plans.
Yes, very, very important.
We have, oh my goodness, we have about 5 minutes left. Listen, someone, I think you answered this before, but they want Real Isis good night. She wants to know you to make the differentiation between a deed of gift versus the will.
Right.
I think you did that already.
Right. So a deed of gift is a transfer of the legal ownership of a property while you're still alive, while the legal owner is still alive. So
Right.
as soon as the legal owner signs that deed of gift in front of the witness, that property is transferred right away, same time. When you have a will, the will only speaks after death.
Right.
And the property that is contained in the will can only be transferred after death and can only be transferred after the will is probated. So you have what we call inter vivos, or while you are alive.
Mm-hmm.
The deed of gift is an inter vivos transfer while you are still alive. But the will now only speaks after death. And the legal transfer can only be occur after the will is probated. So if you want to give your property away while you're still alive, the deed of gift is the better option.
Yeah.
All
I'm
right?
thinking,
Yeah.
then all of this confusion. Oh my
Right? Yes.
goodness, there is so much those. Yes, Tanisha. She said this is so educational. I am finding it so. I feel like we don't have enough time, but it's good. But it's great. You're doing a great job. Somebody says, let me make sure I want to get one more question in, Corey.
Right.
Uh oh, this was a good one from Carol. Says you can see it there.
Yes. Right. Yes, very, very, very good question. Um, I have found this has come up in my experience, and I will answer it by saying again, everything should be done for the benefit of the beneficiaries. And if the beneficiaries determine, let's say, for example, the will states that the property is to be sold.
Mm-hmm.
The property is to be sold, and the proceeds of the sale be distributed to all the beneficiaries. The beneficiaries can determine by mutual consent, well, I really don't want to see the property sold. And they can instruct the executor not to sell the property. They're basically telling the executor, yes, we will still get the benefit of the property, but we don't want the money. We want the physical asset. We do not
Mm-hmm.
want the physical asset to be sold. And the beneficiaries have the right to make that decision. And they have the right to instruct the executor not to sell the property. Because
Mm-hmm.
at the end of the day, even if the executor believes that the property should be sold, at the end of the day, the executor is supposed to act for the benefit of the estate. And the estate says this asset is supposed to be for the benefit of the beneficiaries. So if the beneficiaries are saying, well, we don't want the money, we want the physical asset, I see no reason why
Right.
the beneficiaries cannot instruct the executor, do not sell the property. Just transfer the property to us and we will determine what we want to do with it at a later date. Yeah, so the answer to that question is yes.
Yes. Excellent. It answers yes. Well, thanks again. This one seemed like it went too fast.
Yes, very, very
But
quickly.
thank you very quickly. Yes, and it's you got you got the 30 minutes in,
Right.
but it just seemed like it went fast. But thank you so much, and God bless. And we hope
You're
that
welcome.
whatever you didn't cover this time around, that you can cover it next week, Monday, God willing. And once
Yes.
again, people send me the questions, and I will send them off to Attorney Beckles. Thank you so much. Wonderful job. God bless you.
Thank you for having me. Have a good evening.